Hello and welcome to Byjus Exam Prep IAS. Before we start with our today's analysis, we have two important announcements. In continuation with our knowledge series, the topic for today's discussion is preamble. Please do tune in live on our YouTube channel at 8 p.m. so that you understand everything about the preamble. This lecture will be delivered by Sarmat sir. The second announcement is in reference to the Independence Day. Tomorrow being 15th of August Independence Day, we would not be uploading the Byjus CNA as well as the daily quiz on our YouTube channel. Let's get started and look into the first article. The first article says digital lending. What is the context? We have the Reserve Bank of India, which has instituted a framework for regulating the digital lending landscape in the country. So the first question that we have to understand is what is this digital lending? As the very name denotes, lending on the digital platform. What are the digital platforms? Let's say for example, we have a mobile application that is developed, giving loans to people on the mobile application, or people visit a website, giving these loans on the website platform is what is called as digital lending. When we look at the traditional lending aspects, what exactly happens? You have to go to the banking channel, you have to fill large number of papers, there is KYC norms, so on and so forth. Ultimately what you will have is a cumbersome process in the traditional system. But when it comes to the digital lending, all that you have to do is download an application or visit one of the websites, and all of this happens on a faster basis. So digital lending basically means lending that happens on the web platforms or the mobile applications, making use of the technology for authentication and credit evaluations. How does this work? When we speak about the digital lending process, first what we have is the customer acquisition. What is this customer acquisition? Basically, people who would want to get some loan or they want some money, they should be able to download this application. So the first parameter of the digital lending is acquiring the customers so that these customers are able to take the money from that particular application or the mobile platform. Then what we have is the assessment and the analytics. What is this assessment and the analytics? Basically, you have a person who will require the money. Whether this person would be able to pay the money back or not, who is this person, where does he reside, why does he want the money, is this assessment part. Then what we have is the sanction and the payment. What is the sanction and the payment? Once the analysis of that person is done, what this application owner will do, the lending application will do is it will sanction the money immediately, and after a prescribed period of time they would also be able to collect the money as well. So what we have is a 4-level process. First is the customer acquisition, second is the assessment about the customer, third is giving the money, and fourth is the collection of the money. If we look into the statistics, the value of digital lending rose from USD 33 billion in financial year 15 to USD 150 billion in the financial year 20, and it is projected to reach about USD 350 billion by the financial year 23. This basically means that digital lending utilizes the automated technology. What we have is algorithms for the decision making, customer acquisition, disbursement and recovery, and everything happens on a faster and a speedy process with much better lending cost as well. So what are the advantages or the benefits of the digital lending and borrowing system? The first happens to be no physical documentation required. When you consider the traditional channels of lending, we have the banking channels. Let's say for example, you go to the SBI. So what happens in SBI? You will have to stand in the long queues. You will also have lot of paperwork to be done, and people do not respond properly as well. They'll ask you to move to this cabin, this counter, and this process is a cumbersome process. It takes a lot of time as well. In order to avoid it, what you have to do is all that you have to do is put in your digital imprint of that particular certificate or that data and immediately upload it. You don't have to go to the counters, you don't have to ask people as well. There'll be a set of documents that this application would ask you for. All that you have to do is make a PDF of this document authenticated via the OTP, and immediately after this what you will do is upload. So no physical documentation is required. So that's the first advantages when it comes to the digital lending. The second happens to be the quick dispersal. What happens when when it comes to the traditional system, it does take a lot of paperwork, and for you to receive the money, it will take a long period of time as well. But here, the minute you upload all your documents, there'll be OTP authentication that immediately takes place. The minute this is done, you will have your money in your bank account. That's the second advantage. Third is the ideal option in case of emergency. Let's say, for example, you have a wedding, or someone is met with an accident, or you require the money for the personal use as well. In all these cases, you would not be able to go to the banking channel, take money from them, because it is a long drawn process. They would also have a lot of procedures as well. So why go to the banking system? Go to the digital lenders, where they would be able to give you the money on a faster basis, even in case of an emergency like wedding, personal use, so on and so forth. The fourth happens to be financial inclusion. Large number of people who may not be able to get the loans or not able to get the money would be getting the money at a faster basis, and they become the part of the financial inclusion, where they are able to get the credit from these digital applications. These are some of the advantages with respect to the digital lending. However, for the past few years, what we are seeing is challenges when it comes to the digital lending. What are these challenges? When we speak about digital lending, what exactly happens? One, you give your data. The minute you give your data, what exactly happens? This person is taking your data, and what if he takes your data and sells it to the third party? So there is breach of privacy. So the first major issue is this person might collect your data, he might put it into his database, but what if without your consent he is giving this data to someone else? Imagine that you're getting a call that do you want the loans. Imagine you're getting calls for the personal loans as well. So they pick up the data and transfer it to some third party, even without you giving consent to it. So the first major concern with all these digital applications is the privacy, where privacy is not being respected by these digital platforms. So what do? They sell your data, and privacy will become a major problem. The second major issue, once the loan or the lending happens from this particular digital application, you have to pay them on a timely basis. In case you do not pay them on a timely basis, they threaten people as well, and when they threaten people, they also speaks obnoxious words as well, cursing words as well, where people who are sensitive are not able to take these words, and ultimately there have been instances where people have passed away as well because of the torture that has been perpetuated by these digital applications. So second major concern is that these people, when they are not able to pay, what they do not have is a proper protocol, and instead they go on to threaten such people. The third is with respect to high charges. What do we mean by high charges? Let's say, for example, there is a person who has taken the loan. The person is not able to pay back the loan. Even if he is able to pay back the loan, it is not like 5%, 6%, it will be 25%, 35%, so on and so forth. So the amount of interest that this person who has taken the loan is also quite more as well. So what are the issues faced by the customers? One, unbridled engagement of third parties, mis-selling, breach of data privacy, unfair business conduct, charging of exorbitant interest rates, and unethical recovery practices bothering consumer confidence, said they have to be mitigated, which is why the Reserve Bank of India has come up with some rules and regulations added to it. If we speak about the lending service providers, they act in partnership with the non-banking financial companies who disperse credit to the customer using the former's platform, making it a multi-sided platform. So when we speak about digital lending, what we have is number of people in this particular market. There are more than 1,000 people who are in this particular market. Between January and the end of February in 2021, there were about 1,100 lending apps available for Indian Android users, of which 600 were illegal. So we have large number of people who are present in the market who are ready to give loans to the people. Because there is large number of people in the market, they would only be able to serve small number of people, because there is a cutthroat competition, and as a result what they do is impose high interest rate on all these people. So the major factor being, despite the cutthroat competition and they are catering to a small number of people, the interest that they charge is comparatively more. The absence of standardized disclosure and regulatory norms made it cumbersome to access a participate operational legitimacy. One, they give this particular loan and the terms and conditions are also not proper as well, and they change as per their whims and fancies. Further, they were either unregulated regulated by the RBI or had NBFC partners with an asset size of less than 1000 crores. Because these apps were running illegally, they were not being regulated by any of the laws of the country, which is why we have the Reserve Bank of India, which tends to feel that it has to regulate it. So what are the new regulations come up by the Reserve Bank of India? Lending must be carried out by entities that are either regulated by the Reserve Bank of India or possess permission to operate under a relevant law. So only those which are given permission by the Reserve Bank of India, regulated by the Reserve Bank of India, or under any law of the country, only those should be able to provide lending, says the first regulation. Considering the large scale outsourcing in the industry, this would also help address regulatory arbitrage as well. The Reserve Bank of India has mandated that all loan dispersals and repayments are to be executed directly between the bank accounts of the borrower and the entity, eliminating the involvement of LSP's nodal pass-through account. Henceforth, before executing the contract, lenders would have to inform the borrower in a standardized format about all fees, charges, as well as the annual percentage rate. What exactly happens? As of now, when you look at these digital applications, they go on to change the terms and conditions every now and then. So before you give the loan, make sure that what fees you are charging, this has to be crystal clear. It has to be a transparent process. How much is the interest that you are charging? That has to be crystal clear. And what is the annual percentage rate? That has to be crystal clear. You cannot change according to the whims and fancies is the next recommendation. Also, to address the need of a dedicated resolution framework, entities would also have to appoint a grievance redressal officer. So if this digital application is giving the money and if people have paid but they have some grievance, what they have to come up with is a grievance officer for that particular application. And at the same time, the ecosystem will also fall under the purview of RBI's integrated ombudsman scheme should the complainant not be resolved within 30 days of receipt. So this person who's faced the grievance puts it to the grievance officer. The grievance officer will have to resolve this query within 30 days. If it is not done so, then the same will be reported to the Reserve Bank of India. Added to it, we did discuss about data being sold to the third party. So if this particular organization has taken the data of the individuals, this data, if it is being sold to the third party, the permission or the consent of these people will also have to be taken. Added to it, users can also revoke previously granted consent as well. Let's say I have given permission to one of the digital applications. If I say that you do not have to hold this data, I can also revoke this permission, says the Reserve Bank of India. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, why will airlines have to share PNR data? Let us try and understand what is this article all about. The Passenger Name Record Information Regulations 2022 was notified by the Central Board of Indirect Taxes and Customs under the Ministry of Finance. So what does this mean? It means that the Central Board of Indirect Taxes and Customs has requested all airlines, let's say SpiceJet, or let's say for example we have Indigo, they would have collected information from the people. They would have entered India, they would be leaving India. So all this information that they have collected should be given to the Central Board of Indirect Taxes and Customs. So this article here is speaking about why such a proposal was made. It is also speaking about concerns associated with it. First, we have to understand what is this passenger name record. When we speak about passenger name record, it is the personal information that is provided by the passengers, collected and held by the aircraft carriers. Let's say for example, if I am traveling in the aircraft, what is the information that I give to that particular airline company? I give my information about who I am, date of the intended travel, all available contact details or available payment, whether I've made it via the cash or I've used my credit card or I've used my debit card, travel status of the passenger, confirmation, check-in, check-out status, baggage information, seat information, travel agency or agent from where the ticket was issued. All this information will be given to the airline company. So this information given to the airline company will now have to be shared with the Central Board of Indirect Taxes and Customs. So the CPEC will set up one of a database called as the National Customs Targeting Sector Passenger to collect passenger information for the risk analysis. So this risk analysis basically means that in case there are people who are bringing narcotics to the country, or they're smuggling gold, or they're bringing arms and ammunition, all of this will be regulated with such a data collection. So the significance of this is used for preventing any types of illegal activity. And in case there is an airline, if they have failed to share the data, in that case what we will have is the imposition of a penalty of about 25,000 to 50,000 for every act of non-compliance. So this airline company will have to share the information with the CBIC before 24 hours. So even before the land, 24 hours before the land, they have to share this information about people who are entering the India and people who are leaving India. Now the question is, this data is collected by the CBIC. Can it be used by other agencies as well? Yes. Let's say for example, CBI has to use it. They can go ahead and use it. Let's say for example, raw agency will have to use it. They can use it. If intelligence bureau want this data, they can also use it as well. And at the same time, this data can also be sent to other countries as well. All of this will be regulated in this particular law. What is the positive aspect of this regulation? Earlier there was haphazard way of getting the information. There was no standard procedure as well. So any agency, let's say for example IB or the CBI, in case they want to ask the information, they would go on to ask the information without any due process, or there might not be any standard procedure that has been established. But in the present situation, what we will have is a established procedure. So CBIC would establish a procedure, and as per this procedure they would be able to collect the information. Earlier they did not have a standard procedure. They would also be able to prevent any illegal activities that may surface in the near future. However, there are challenges as well. What are these challenges? Whenever a program or a set of rules is being implemented, there are set of stakeholders as well. Who is the major stakeholder right now? It happens to be the airline company. So the government agency, whenever it is drafting clear-cut rules in the near future, they may also have to hold the consultation with these stakeholders is the first major challenge. The second is, there is one of the customer who has given information but has not given all the information. But the CBIC wants this information, but the airline is not able to get this information because the customer itself has failed to give this information. In such a scenario, is it going to be the airline which will be penalized, or is it the customer? So in this particular backdrop, the draft does not speak much about it. The regulations does not speak about it. So we have to have a clear-cut idea about the same, says this article. However, the Indian agencies collecting the passenger information earlier, the Bureau of Immigration collected passenger details under the Advanced Passenger Information System following an amendment in 2008 by the Ministry of Home Affairs to the Foreigners Act of 1946. This allowed collection of data pertaining to foreigners but not Indian citizens traveling in and out of the country. The APIS is contained in the departure control system of an airline and captures data when passengers check in at airports and transfers the details to the destination country 15 minutes before the flight departure. So what is the major difference? According to the now regulations, they have to give the information before 24 hours. Earlier it was just about 15 minutes, and now it is before 24 hours, so that they would be able to stop all the illegal activities. How will this information be safeguarded? We have the CBIC, which says that the format for data exchange between the airlines and the customs systems is a standard electronic message format endorsed jointly by the World's Custom Organization, International Civil Aviation Organization, and the IATA. So there have been a prescribed code that is already in place. This program, this algorithm or exchange of data makes sure that privacy of the individual is also taken care as well. As per the regulations given by the Central Board of Indirect Taxes and Customs, it has also said strict information privacy and data protection will also be taken care as well. Hardware and software that is necessary for the data protection is already being built as well, and at the same time, whenever there is the processing of data, anything which has to reveal the ethnicity, race, religious or physical beliefs, health, etc. is strictly going to be prohibited. So this article currently goes on to say, even if the information has to be extracted, it can only be processed by a senior officer of the rank of principal additional director or additional director general who would be able to take the data. So remember, what this article currently also goes on to say is that such data will be retained for a maximum of period of 5 years, after which it will be disposed of by depersonalization or anonymization, but can be repersonalized and unmasked when used in connection with the identifiable case, threat or risk for the specified purposes. But there are also challenges with the privacy as well. What do we mean by it? Let's say, for example, we have the CBIC, which is collecting data of all the people who are stepping in. In case it is only a section of the people, why not collect information of those people? In case they have a doubt, they suspect one of the individuals, why not collect only this individual's data alone? Why collect all the information is the first major issue. The second, we do not have the data protection law as of now. The government has also withdrawn the bill as well with respect to the data protection. So how will the data be protected is very ambiguous, is very opaque and is not transparent, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says Colombo clears arrival of Chinese vessel. Let us try and understand what is this article all about. Sri Lanka has cleared the arrival of Chinese space and satellite tracking vessel Huan Wang 5 at the southern Hambantota port. So there are two aspects to it. One, it speaks about the Hambantota port. Second, it speaks about the Huan Wang 5, which happens to be a satellite tracking vessel, and this will be entering Hambantota port. So India has its share of concerns, says this article. First, we have to understand Hambantota port. Where is Hambantota port? It is on the southern part of Sri Lanka. This happens to be a deep sea port, the second largest in Sri Lanka, sits on the route connecting Southeast Asia with Africa and West Asia. As part of the assignment, you have to put on the comment section which is the largest port in Sri Lanka. This happens to be the second largest in Sri Lanka, but which is the largest? Please put it on the comment section. For China, this Hambantota port is part of the One Belt One Road initiative. Its development was largely funded by China, but this project is commercially unviable project that former President Mahinda Rajapaksa built in his home district with borrowed Chinese money, which the government of President Matripala Sirisena and Prime Minister Ranil Wickremesinghe were forced to hand to China on a 99-year lease in 2017 against a debt of $1.1 billion, which they were unable to pay. Sri Lanka also handed over 15,000 acres of land around the port to the Chinese. Sri Lankan officials had said that at their time that their total debt to China was about $8 billion as well. So in this particular backdrop, what we have to understand is that there is one of the ships, it is entering the Hambantota port, and if it enters the Hambantota port, India has its share of concerns. So next, what we have to understand is in reference to Huang Wai 5. What is this? This ship was constructed in 2007 by Jiangnan Shipyard and is owned by the Chinese PLA. It is a Chinese research and survey vessel. China uses its Huanwang class ships to track the satellite, rocket, intercontinental ballistic missiles as well. If you look into this image, it currently has these huge antennas. It would be able to monitor the satellites of the Chinese as well. And as of now, this particular ship is traveling to Hambantota port. Why? That is mainly for refueling and replenishment purposes, and this will also conduct satellite control and research tracking of China's satellites in the northwestern part of the Indian Ocean between August and September. But why is India concerned about this development? That is because it has top of line antennas and electronic equipment which will be able to track missiles as well as the rockets. This ship can oversee a distance of about 750 km, which means all the strategic assets of India on its eastern coast can be on the surveillance radar of this particular ship. Added to it, reports have also claimed that several vital installations in South India could be under threat. They can also also be snooped as well, and the docking of the Chinese ship in Hambantota also has a huge implication for Tamil Nadu, which also has a coastal area of more than 1000 kilometers. Kalpakkam nuclear power plant, Kundamkulam nuclear power installations, besides several other strategic assets of India can be eavesdropped from this particular location. The vessel can also spy on India, and it can also spy on the ISRO satellite base at Sriharikota as well. Besides, Tamil Nadu police have also received intelligence input from Delhi of a possible demonstration by pro LTTE elements in the state against the arrival of the Chinese ship. It is also on guard against the possible entry of some of the LTTE sympathizers in the guise of the Sri Lankan refugees. So you may have the LTTE supporters who may also enter India as well. That is because they do not want the Chinese in Sri Lanka, and as a result they may protest against the Chinese in India, and this can also lead to law and order problems, says this article. What has been the response of India? India's Ministry of External Affairs spokesperson has said, and I quote, "We are aware of reports of a proposed visit by this vessel to Hambantota. The government carefully monitors any development having a bearing on India's security and economic interests and takes all necessary measures to safeguard them," says India's External Affairs Ministry spokesperson. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, have coastal ecosystem norms be violated? Let us try and understand what is this article all about. The Comptroller and Auditor General of India tabled a report in Parliament on whether steps taken by the Union Environment Ministry to conserve India's ecosystem has been successful. What do we mean by it? The Government of India in the past has come up with number of laws to ensure that the coastal lifeline of India is safeguarded. We have number of illegal activities, construction that can take place in the coastal regions. In order to regulate it, what we have is the Government of India which has come up with number of laws, schemes and policies as well. Whether it has been successful or not is what is this report which has been submitted to the Parliament. In the past, we have the Government of India which had issued notification under the Environmental Protection Act of 1986 to regulate activities along India's coast, particularly regarding construction. The Coastal Regulation Zone Notification 2019, implemented by the Ministry, classifies the coastal area into different zones to manage infrastructure activities and also to regulate them. The three institutions responsible for the implementation of the CRZ are, what we have at the national level is the National Coastal Zone Management Authority at the center. At the state and the union territory level, what we have is a state or the union territory Coastal Zone Management Authority at every coastal state and the union territory, and at the district level, what we have is the district level committees in every district that has a coastal stretch where the CRZ notification is applicable. As per all these notifications and laws, in case there is a developer who has been given the permission to construct along the coastal areas, whether this person is following the prescribed standards will also be taken into picture, and at the same time we also have the Comptroller and Auditor General which had also evaluated measures taken by the government towards achieving the targets under the sustainable developmental goals. What has the Comptroller and Auditor General said about the coastal regulation? It has said that there have been large scale illegal construction along the coastal areas, and at the same time there are effluents that are directly discharged into the seawater. They are not treated, they are not filtered, and they are directly dumped. This is also hurting the aquaculture as well, and at the same time there is large scale CRZ violations in the coastal stretches, says the CAG in this particular report. For one, the Environment Ministry has also not notified the NCZMA as a permanent body. It was being reconstituted every few years in the absence of the defined membership. It was functioning as an ad hoc body, so this should have been a permanent body investigating what is happening at the national level, but unfortunately we do not have the prescribed number of people appointed to this particular committee, and as a result this is acting as an ad hoc body and not not as a permanent body, says the CAG. The SEZMA, which is the authority at the state level, had not been constituted in the state of Karnataka. There were delayed reconstitution in the states of Goa, Odisha as well as West Bengal. The district level committees of Tamil Nadu lacked participation from the local traditional communities. In Andhra Pradesh, DLCs were not even established as well. There were also instances of projects being approved despite inadequacies in the environmental impact assessment reports. Added to it, the article further goes on to say that when it comes to different states, they also have issues as well. Tamil Nadu didn't have a strategy in place to conserve the Gulf of Mannar Island. In Goa, there was no system for monitoring coral reefs and no management plans to conserve turtle nesting sites. In Gujarat, instruments procured to study the physiochemical parameters of soil and water of the inertial area of the Gulf of Kutch weren't used. Sea patrolling in Gairmata Century. In Kendrapara, Odisha did not even happen as well. And at the same time, there was no website to disseminate the information related to the national authority, said the CAG when it reported all these issues to the parliament. This report is currently placed before the standing committee of the parliament, and in all likelihood, we will have the opposition and the legislature question the executive about the environmental laws in safeguarding the coastal regulation zones. It is this that we have to understand with respect to this article. Now let's look into the mains practice questions. The digital lending sector has come into spotlight because of the proliferation of extortionary lending practices. Discuss the RBI's new digital lending rules to curb rampant malpractices in the digital lending ecosystem. What are the pros and cons of customs wanting passenger name record information on international travelers? How will the process work? So please write all your answers on the comment section. In case you wish to upload an image, visit the Byjus exam prep website and you would also be able to upload the image of your answers as well. So this is it for today. Thank you for watching. All the best.